there. So Richard, thank you so much for joining us
Sure.
today. We've partnered with you for several years now and always learn a lot. And I know today we're going to learn even more. So I'd like you to take a moment to tell a little bit about your firm. For those that don't know you, I don't know who in Southwest Florida doesn't know Richard DuBost, but I'll hand it over to you.
Sure. Thank you, Laura. Richard DuBost, Godey DuBost and Cross. We are a full service law firm, but our primary practice area is community association law, condos, HOAs, co-ops, mobile home subdivisions, et cetera, et cetera. I want to thank Castle for putting this on. We do a lot of these, but Castle does it about as best as it can get done. We always have a good turnout, and I'm looking forward to a good seminar.
All right, great. Okay, I am going to stop sharing my screen and let you share yours, Richard.
Okay. Share screen.
And Richard's presenting today, everybody, a PDF that we will send out. Sean and I will follow up with everyone who is on today's webinar and anybody who registered for the webinar. So we will send out Richard's contact information, our contact information, and a copy of this PDF that Richard's sharing with us.
So you can see the outline?
Yep.
Okay. If I'm looking to my left, that's because it's on a screen over here. So I'm not looking out the window at the beach. So there's a lot to go over today. And so I'm gonna, I tend to talk pretty fast. We'll take questions as Laura mentioned. First of all, this is not specific legal advice to your particular community. This is a general overview of the laws affecting community associations that were adopted in 2024. If you have specific legal questions about the applicability of these laws to your circumstances, you need to talk to your legal counsel, or feel free to call us or whomever. But I get all the time, well, Richard DuBost said, and I said, well, they're not even my client. Well, we watched the seminar. So, it's my legal interpretation of these laws, but it could be factually different for you. So just keep that in mind. With that, I'll just jump right into it if we're ready to go, Laura.
That sounds great.
Okay, the first three here only pertain to condominiums and co-ops that are 3 stories or more in height, with at least more than 4 units above or more. Okay, this all goes back to the SERS and milestone study laws that were adopted 2 years ago and then amended a year ago, and they've been amended again. So this is all flowing out of the Surfside Champlain Towers collapse. Again, it only applies if you're 3 stories or more in height, condo or co-op. There's not a whole lot here, but I'm going to run through it. First of all, previously the milestone inspection, and I'm not going to go into detail as to all of that if you fall into this category, you should have heard of these things a lot.
Yeah.
For the good or the bad. But the milestone inspection that's due after your building reaches 30 years old formerly had an exception that it did not apply to if you had only 3 stories and 3 habitable units above ground. It's now been extended to cover 4. So if you're a 3-story building with only 4 units, you're not required to do the milestone study, nor are you required to do the SERS Structural Integrity Reserve Study. It expanded the pre-existing exception for 3-story buildings with 4 or less units in them. Number 2, if, God forbid, we get another disaster like Hurricane Ian or other hurricanes that makes your building uninhabitable, you can't live in it while it's being reconstructed, and you're required to fund those SERS reserves because you're 3 stories or more in height, you can now waive the funding of those reserves during the period of uninhabitability of your building. Why are you collecting reserves for something that you're building brand new already is kind of the idea. The third one here, SERS reporting. Now within 45 days of receiving your structural integrity reserve study, you have to notify the owners that you have it and give them a copy if they want it. You also have to notify the state that you have obtained your structural integrity reserve study, and they're going to keep track of whether you have it or not. And if you haven't got it within the time provided, there may be penalties that would pertain. So that's it for the changes to the SERS and milestone study laws. And now we're going to get into just the general changes to chapter 718, which is only for condominiums. This does not apply to homeowners associations. What I'm going to talk about for the next few minutes does not apply to cooperatives. It's chapter 718, the Condominium Act. So the first one is just a definitional change here in item number 1. You don't need to worry about that. Nothing that really pertains to that. Number 2, hurricane protection. Traditionally, under chapter 718, hurricane protection was defined as hurricane shutters, because back in the day when hurricane protection started, it was traditional shutters that we're all aware of: roll down, slide across, panels, whatever. Now the technology has increased, as we all know, to have hurricane rated windows and doors that don't require shutters. So they've expanded the definition of the term hurricane protection to include all types of code compliant hurricane protection. So what that means for you is when your board, your condominium board, adopts a hurricane protection specification, which traditionally might have been, you can only use roll down shutters that are the same color as the building, mounted in a certain way. That's the specification that people had to follow. Your specification now could be, you can only use hurricane rated windows and doors, and that's what you can put up, and that's what you have to replace with. So it has expanded the coverage of that definition. Kickback. We're going to get into kickbacks more in other parts of the statute, but in the definitional section, they've added what the term kickback means, which is anything of service or value for which consideration has not been provided for an officer, director, or manager's own benefit or his or her immediate family. Basically, the idea is if a vendor came to you as a manager or came to you as a board member and said, hey, I'll give you $100 a month if you make sure I get the landscaping contract for this community. If you did that, you've now taken a kickback, which is a violation of the criminal law, and you can be criminally prosecuted. But that's what a kickback is. Doesn't have to be money. I had a situation once years and years ago where the landscaper, after we got rid of the manager, the landscaper said, you know, that manager you had, he wouldn't give me the job unless I also cut his mother's grass every Saturday for free across town. That was a kickback. Okay. Condominium within a condominium, number 4 here, that's a developer thing. Just something developers wanted to create a condominium within a condominium. It's not going to pertain to anything relevant to your day-to-day operations as a already completed community. Again, residential and mixed use condominium hurricane protection. This now requires, when you have what's called a frequently asked questions and answers sheet, which each condo association is supposed to maintain every year. And when a new purchaser comes in and says, I want to buy in here, you're required to give them the frequently asked questions and answers, which has about 10 questions on it, like, can I have dogs? What's the rental rules? This isn't required to be on that document, but this new requirement is perfectly fitted to be on that document. What you have to do is you have to tell the potential owner who is responsible for maintaining, repairing, and replacing the hurricane protection. Is it a unit owner responsibility or is it an association responsibility? You have to tell them that. So that's a perfect thing to add to your frequently asked questions and answers. Who's responsible to maintain, repair, and replace hurricane protection? Question mark. The association is, or the owner is. So go ahead and add that. Here's what we talked about. Accepting a kickback is a crime. In addition to be a civil penalty, accepting a kickback is a 3rd-degree felony, and you are immediately removed from office. So, you know, that's pretty serious. Yeah. All of this stuff really came out of the, I always forget the name of the place, the HOA over in Miami-Dade County that was the corrupt organization basically, and the board was doing all kinds of bad things. Most of these laws have come out of that debacle and filtered now into the Condo Act and the HOA Act to make a lot of things that board was doing wrong, criminal. And we'll get into more of that later. Fidelity insurance bond. Everybody is supposed to have, every board member is covered with a fidelity insurance bond for the maximum amount of money that they might have under their control during the year. Now the division is going to monitor the compliance with that to make sure you have that fidelity insurance. So if somebody steals your money, your management company or your or your board member steals your money, you have insurance coverage to refund the money. You have to have that insurance by law, and they're going to more closely monitor that you do or you don't have it. And if you don't have it, you can be subject to a civil penalty. Official records. This just clarifies that email addresses and fax numbers of the unit owners that were not provided as the official form of communication by the owner are excluded from an owner being able to obtain the facsimile number, or whoever uses faxes anymore. I don't know. That's I guess they still exist, but email addresses. So basically, when the owners come and say, I want all the email addresses of my fellow owners because I want to send them, scathing emails about the board, unless those email addresses were provided to the board with the written direction of the owner saying, do not mail me anything at my home that comes from the association. I only want email to be my official address. If email is your official address, other owners get that email address too. If your email was not provided to the association as your official form of communication, it is a protected address that is not disclosable to other owners. So in most cases, and I know Laura and Sean are probably can attest to this, most associations have quite a list of email addresses, and they use them frequently to update all kinds of things and give out information. But when it comes to actually mailing the official communication, like official notice of the annual meeting, official notice of the board budget meeting, that is still traditionally sent to the hard physical address, because that's what most people still use for their official address, not their email address. But in any case, the email address is generally protected. Another thing is the association now cannot sell your email address. I guess I had never heard of this. Laura or Shauna may have heard of this, but apparently there must have been some associations or maybe possibly management companies that were selling the email address list of a particular community. Well, now that is expressly made prohibited. You can't sell the email address to others.
No, I didn't. I was always under understanding that was private information. You weren't allowed to send it out, period.
Yeah, that is. The next one, and again, I'm a little bit cynical, and I know Laura and Shauna, who are in the business, I got to tell you, these legislators, they get pounced on by the 2% of the homeowners that have been abused and treated badly and have bad boards that have done bad things. They get pounced on by these people and get their ear very quickly. And all the legislator typically hears is the horrible horror story, which is 2% of the bad boards that do bad things, don't give official records, do bad things. Unfortunately, what results in that, and I'm pontificating here a little bit, is the legislators think they're doing a good thing by stopping all this criminal activity, which needs to be stopped. But they impose laws and rules that they don't understand how in the practical world your manager, your board, your lawyer has to deal with this stuff, okay? And it becomes, a bureaucratic nightmare to deal with. And I'm going to get into more of these laws later. And unfortunately, there are laws already in effect to take care of bad boards, but now we're getting more and more weaponization of the statutes, that if the board doesn't do this, it can be a criminal penalty. If the board doesn't do that, or the manager doesn't do that, you can be allegations of criminal activity. Sounds good on paper, becomes a nightmare for the board that's just trying to do the good thing and not do the bad thing. Anyway, enough preaching. So one of the things they've done here is they've added to the official records list, and it now says all invoices, transaction receipts, or deposit slips that substantiate any receipt of money or expenditure of funds are now official records, as are building permits and board certification course certificates. What that means to me is, if a board member or the manager goes to Home Depot and buys a light bulb for $1.50 and gets a receipt, they got to turn that in, and it's an official record kept by the association. You can imagine the amounts of paperwork this is going to create, but that's what it says. Obviously, building permits are something that are not difficult to keep, but this is just going to add in my mind, a lot of work to keep all these receipts. Obviously, the credit card statement shows it, but this says you
It
got
does.
a receipt, right?
Yeah, and keeping the receipt. I know that the receipts, we do a credit card reconciliation, which lists out which, you know, who it was purchased by and the amount of, and then receipts are all attached that, you know, proof is backed with that credit card reconciliation and then scanned into our Castle Click. So.
Okay. Well, maybe it's not as much work as I thought, but it
Yeah, it sounds like a lot of, if people are not running through, either they're using petty cash on site, which we don't do, you know, we recommend the association have a credit card, association credit card, and then you have the credit card reconciliation, you keep all the receipts and all of the documentation is there to support what was spent.
good. Okay, number 10 here. You now have to keep the official records in an organized manner that facilitates inspection of the records by the unit owner. I mean, obviously, you always kept the records in an organized fashion, but the law didn't require you to. So sometimes when an owner would make an official records request, and it was the 15th official records request of the year that they had made, you know, sometimes you just point to the filing cabinet and say, go look at it, it's in there, and let them hunt and peck and try to find the stuff. You know, which was kind of not done fairly, but we all know the person that's the serial records requester that really isn't looking for anything other than something they think they can use against the board. Now you've got to keep the things in an order, which you already do, you know, so insurance policies would be in a file called insurance, and landscaping would be, so you got to do that in good faith. You can't just throw all the junk in a barrel and say, go look in the barrel. Anyway,
Right.
this stuff is online anyway now.
Right. We've got one question from Joan. She asked, can official records be strictly electronic files to avoid all the printing?
Yes, you can do that. And as we get into this, the solution to all these new official records laws, in my mind, is put as much as you can in the cloud and make it available through the secure portal on your website. Then you can simply say, it's on the website, it's on the website, it's on the website. Nobody coming in your office, nobody claiming you didn't do it within 10 business days. We'll get into more of that. But the other thing is, in the event the official records are lost or destroyed, you have to make a good faith effort to recreate them or get replacements. This came out of Hurricane Ian a lot, where, you know, literally the records were in the Gulf of Mexico. You got to make a good, you know, if that's the case, there's not much you can do other than call the insurance company and say, can you send me a new copy of my policy or something?
Right. Richard, I've got Dominic as if there's a deadline to start complying with having receipts recorded and kept. Meaning from what?
All of these laws were effective July 1, 2024. So your requirements started July 1, 2024. Here's the answer to that other question. If your records are available on the association's website or a downloadable mobile device, the request for records may be filled by referring the person to the website. That's the answer to all of this, what I'm going to get into next. And here's what I'm talking about. Well, a couple of these things. In response to a written records request, the association must now, and this is condo only, simultaneously provide the requester a checklist of all records that were made available in response to the request and those that were not made available. When it's on the website, I don't know how you provide this document, but traditionally you would say you asked for A, B, C, D, and E. Here's your checklist. We have provided you A, B, and C. We have not provided you D. D was a request for all the email addresses, and that's not an official record available to you. That would be something like that you have to do.
I have another question back on receipts real quick. Original receipts or copies are both acceptable?
I think either one. You know, if it's an exact copy, that would be sufficient. Okay, official records, more of this. Okay, here's where putting it on the website will get you around this. Right now, the new law is if a director or member of the board or the manager knowingly, willfully, and repeatedly violates this paragraph by failing to provide access to records, it now commits a misdemeanor of the second degree. That's a criminal charge and must be removed from office and a vacancy declared. This repeatedly means 2 or more violations in a single 12-month period. So If somebody made an official records request, I want to see the insurance policy in January. You didn't give them access to it. Then in March, they said, I want to see the insurance policy and something else. They made a proper request and you didn't provide it to them, provide them access within 10 business days. Technically, you did that knowingly, willfully, and twice in 1 year or 12-month period, you've committed a crime that you can be charged with. Now, is the state attorney's office going to take these kinds of charges and put it to the top of their list ahead of murders and drug deals? No. I mean, I don't think there's going to be an aggressive effort to do this, but you can see where this is going. You will have the serial records requester. We all know who that person is in your community. And if you don't, it might be you. Okay. That will, oh, I don't think I got that twice in 1 year. I'm now going to allege you've committed a crime. And they're going to create all kinds of, unfounded allegations because of this. This is what I'm talking about. Weaponizing the statute to make criminal act out of their allegation. Now, their allegation may be proven, unfounded and unproven, but they have a basis now to make the allegation, and it's going to create problems. So how do you fix this? All that stuff's on the website. They send you an email and said, I want to see the insurance policy. You send back, it's on the website. Go there. I mean, that's the way to get around what this will create with people that want to use this statute against you. Now, obviously, the bad board that says, bug off, we're not going to give you anything. We don't like you. Yeah, maybe you need this, but I don't see that in my practice frequently. I don't know about you guys.
Right. No, I've got a question from Terry. Are engineer inspection reports considered official records in an HOA? So the reserve study, engineering studies.
Yes. That would fall into the all other written records section of the HOA statute, which is also contained in the Condominium Act, which says everything else related to the association's operation, and certainly a reserve study would be.
Got another, you want one more official records question? Brandon asked, assume it is up to the HOA to decide where to draw the line as to which official records are available real-time electronically. Are things like covenants, rules, and regulations, budgets required to be electronically?
Okay, well, that's a good question, and it leads into another part of the statute we're going to talk about for both condos and HOAs. Depending on the size of your condo or how many doors you have in your HOA, you must now have a mandatory website. And the statute literally says there are certain documents that must be on that website. It's not every official record. It's a subset of official records, which we'll go into, and you can look at the statute. So certainly the governing documents are a required item on the official website, which I'll explain more in a minute. Copies of building permits issued for ongoing or planned construction must be posted on the association's website. There's an example of one. So if you're going to redo the roof and you have a building permit for it, you have to put that building permit on your website if you're required to have a website, which we'll talk about in a minute. There was a question from another seminar. What if the owner gets a building permit to renovate their unit? Does that have to? I don't believe this law requires it's the association's building permit for the association's project. So in my opinion, you do not have to post an owner's building permit on your website for their own renovation of the interior of their unit. But I did have that question once. Financial reporting. What this basically says is you may be aware that you can waive the year-end financial report every year by saying, we're supposed to do an audit, but we're not going to do an audit. We're going to do a compilation. I wasn't even aware of this. Apparently, you were able to waive that with one vote for 2 years. We're not going to do an audit for 23 or 24 with a single vote, but that's not allowed anymore. You have to, I didn't even know it was allowed, but apparently it was, and it's not anymore. So if you're going to waive your year-end financial report, you have to take that vote every single year during the year in which it pertains. Okay. You can't waive it for multiple years with one vote. You can't waive it. Well, that's what it says. Now, debit cards, this was ported over from the HOA statute from a couple of years ago. Debit cards, basically you can't use a debit card in a condo. You can't do it in an HOA either, and I believe co-ops you can't do it either. You can't have a debit card. Why they don't simply just say you can't have a debit card, which we all understand, I don't know but what the law actually says is you can't have a debit card, but if you have one and you use it for an improper purpose, that hasn't been pre-approved, you can get in trouble. But effectively, what this means is you can't have a debit card. And I think the idea behind that was, my understanding is you can challenge charges on a credit card for a certain period of time, whereas a debit card, you can't challenge the charges. It's just gone. Okay. So that's why they don't want boards to have debit cards and they want you to use credit cards. Here's the
Quick
association.
question. Oh, quick question from Mark on the accounting side. So how detailed are the accounting records that are public on our website? We do a short financial, there's a short and a long. We recommend the short financial because it doesn't have delinquencies and, bank information.
Yeah, I don't know that I don't know the statute goes into how far you have to show there. I don't know that it does. So I would rely on what Laura and Shauna are reflecting as standard practice. Association website. So for condominiums, since about 2017, I'm going to say, maybe 18, I don't remember when, if you had 150 or more units in your condo, you had to have an official website and you had to put certain documents on that official website. They've now reduced the number to if you have 25 or more units. By January 1st, 2026, if you have 25 or more units in your condo, you also must have the official website and post those certain records required by the statute on that website. But you've got a little over a year to comply with this. So most communities, even little ones, have websites. But
Right.
The website is not the website that one of your owners will run from his, second bedroom because he's really good with, GoDaddy website setup and stuff. These websites are a very particular type of website that has to comply with certain requirements under the statute. Most management companies, certainly Castle, have the required website. So if this applies to you, it's not just you go out and get a GoDaddy website and set it up. You've got to read the statute and understand the particulars of what you have to put on there. But you can run your own website, but it's just not as simple as setting it up. What I'm getting at. Here's another interesting law. In a residential condominium, not a commercial condo, if you have 10 or more units, the board has to have at least 4 board meetings a year, 1 a quarter. And at that 1 a quarter board meeting, you have to allow owners to ask questions. That's what the statute says. It doesn't say you have to answer the questions, and it doesn't say the questions are limited to only agenda items. See, the law has always said homeowners have the right to attend board meetings and comment or discuss any agenda item. That discussion could include asking questions, or it could just, saying whatever your opinion is on the agenda item. The point is you could limit their time to talk to the board to just the agenda items. That is still the law. You can still do that and say, no, you can only talk to us about the agenda items. But at least 4 times a year, once a quarter, you got to allow them to ask any questions they want, and it's not limited to agenda items. Okay. So, I don't know how many boards said you can't ever ask us a question. I mean, I've been to thousands of these meetings, and Laura and Shauna have too. I mean, that's what half the time they use their 3 minutes for on the agenda item, was to ask you questions. You never had an obligation to answer them, and you still don't. But you have to have at least 4 board meetings a year where they have the right to ask questions on anything, not just what's on the agenda. You could do that at every board meeting, or you could say, no, you got to stick to the agenda for all these board meetings, except those 4 special board meetings a year.
Hey, I've got a question real quick from Karen Richard. In regards to the board meeting, is a board required to add an agenda item requested by owners? If not, how do we get agenda items added to the agenda for a board meeting?
Okay. The statute, and in 718 and 720, frankly, there is, I don't know what the threshold is. I believe it's 10%, maybe wrong, but there is a way for the homeowners to force the board to have a meeting on an agenda item of the members choosing. I believe it's a 10% petition. It might be a little bit larger, And it can also be subject to increased percentage requirements in your own bylaws. But yes, there is a way to the members to force the board to hold a meeting on their topic of choice, but the board doesn't have to do anything except hold the meeting and listen to whatever they want to say. But yeah, there is a way. Other than that, the board basically determines the agenda amongst themselves as to whatever items of business are necessary to be discussed at the meeting.
One other question specific to questions at a board meeting. Stuart asked, can we open the meeting to questions after adjournment?
That's always a good question. The answer is no, because you're still having a board meeting. A board meeting occurs when a quorum of the board is together and they're discussing association business. A board meeting, so a board meeting starts with opening the meeting up, convening the meeting, and the board meeting ends when you adjourn the meeting. If you adjourn the meeting and the board stays up there, a quorum of the board stays at the front table or on the Zoom and says, now you can ask us questions, that's still the board meeting, okay? Because their right to ask questions and their right to speak on agenda items occurs at a board meeting. So you can't close the board meeting. And secondly, a board meeting occurs when the quorum of the board is together in real time. So they're still having the board meeting. So you don't adjourn the meeting. You just keep it open for the Q&A session if that's what you want to do.
Yeah.
And
I've got another good question on board meetings.
Okay.
Charla asked, does mandatory board meetings 4 times a year apply to a condominium within a master condominium? So you're still, and Charla, if we're wrong, I'm assuming you're saying you're a sub-association, but you are a separate association and you're within the master?
If that's the case, if your own association has more than 10 units, yeah, that would still apply to you. The master's board meetings are not your board meetings. Yeah, it's a totally different thing.
Correct. Good question, and good for us to clarify for everyone.
Now, if the master association was a master condo, meaning it only was a master association of condominiums, then it's controlled by Chapter 718 typically as well. And that master would have to have the same 4 times a year ask questions. But most master associations, not all, but most are mixed. They have condos and they have single family homes, and therefore they're not subject to 718. But you'd have to look at your documents. Okay, here's another one that sounds great. Okay, great idea. In practical practice, creates a lot of questions. It now says if the condo board is going to hold a board meeting and consider a contract for goods or services, like we're thinking about adopting this landscaping contract, then a copy of that contract must be provided with the notice and made available for inspection upon written request. So when you post your 48-hour posted notice board meeting on the bulletin board at the clubhouse, and you're going to talk about, a contract, you've got to post the contract with it. Okay, it's got to be there. Now, I had this come up recently where this particular condominium was actually considering 12 different contracts. Okay, and their stack of contracts was about this much, and they couldn't post it on their bulletin board because they couldn't close the door because the thickness of the paper. And I'm like, well, you got to figure out, separate the paper or whatever, but you've got to post the contract with the notice, which, is not horribly bad idea, probably a good idea. But in practical terms, sometimes that's a lot of pages. So, that's just one of the new laws. Okay, director certification for condos and HOA. Prior to July 1, condos, co-ops, and HOAs had the same requirement. If you become a board member, elected or appointed, then within 90 days, you had to take a board certification course, which was a 2-hour course. The course was good for your entire service on the board, and you could take the course, or you could sign a certificate that said, I read and understood the governing documents, and in lieu of the course, I promise to follow all the laws and the documents. You could do one or the other within 90 days. In my opinion, and I know Laura and Shauna have given hundreds of these board certification courses, I thought it worked very well. It was, a lot of information you can dispense in 2 hours. It was very well worth it. In lieu of the course, signing the certificate was not always the best option, but it was there. So I think it worked well. Well, apparently the legislature didn't think it worked so well. So now they have changed the board certification requirements. And did they change them so they're all the same for condos, co-ops, and HOAs like they were before? No, they're different for condos, they're different for co-ops, and they're different for HOAs. So it's not a consistent, and every time we gave a board certification course, it was a mixed bag of, you had co-op owners, you had condo owners, you had HOA owners, you had people that said, I don't know, I live in a villa, I'm not sure what it is. It was one of those, but the course covered it all and it worked very well. But now we have this new requirement. So it's different for condos and co-op. First of all, for co-ops, they didn't change the statute at all. So for a co-op, apparently you can sign the certificate within 90 days, or you can take the course. The course is 2 hours and it lasts for your entire service uninterrupted on the board. Okay, easy. But for condos, now you not only have to take the course, but you also must sign the certificates. You got to do both, number one. Number two, the course is now a 4-hour course based on curriculum established by the state, which the state is publishing the curriculum. We're going to be providing the courses. Castle will be providing the courses. Other law firms are already providing the courses, but we're all getting up to speed on this. But it's now a 4-hour course that must be taken within 90 days, and you sign the document, and the course is only good for 7 years. It's not good. Yeah, so after 7 years, you'd have to take it again. If you were already on the board before July 1, 2024, and you took the old course, you got to take the new course by July 1 of or June 30th of 2025. Okay. So if you just got on the board after July 1, you had to have taken the course within 90 days and signed the certificate. And in addition to that one-time board certification course, each year in a condo now, you have to take a 1-hour legal update. So every year you'll have to take a 1-hour legal update. A lot of law firms put them on, and that's not too difficult. But that's the new requirement for condos. Co-ops are the same as the old one, and when we get to the HOA section a little bit, I'll explain how it's different for HOAs. I believe they will try to coordinate this so that it's all the same for everybody. It only makes sense. I just don't think the legislators were really thinking, you know, one was working on the HOA side, one was working on the condo side. They didn't talk. This will probably get worked out, but for now it's different for depending on what type of community you're in. Directors and officers offenses. This all came out of the, again, what's it called? It's not Homestead. I can never remember the name. It's the community in Miami that was the corrupt organization that created all these laws. This board stayed in power for many, many years, using the association's resources to defend the criminal charges and civil charges against the corruption that they were obviously committing, hiring their relatives to do work that they didn't do the work, pocketing money, doing all kinds of bad stuff. The problem was, while these board members had been charged with these criminal acts, they were not yet convicted. So and they defended vigorously the charges. And if you've ever been through the legal process, you can drag it out. So they drug out that legal process for years and years and years, all the while staying on the board and continuing to steal money and do bad things. So what the law has now done, and I think this is probably good, it now says if a director or officer is charged, not yet convicted, you've been charged with this criminal forgery, theft, destruction of records, etc. When you're charged with it, you're off the board. Now that seems a little unfair in the sense that that's kind of like guilty till proven innocent, which is not what the Constitution requires, you know, innocent until proven guilty. But this says, even if you ultimately are proven not guilty, during the period of time that you're charged with these crimes, you can't be on the board anymore, which I think makes sense. Maybe seems unfair if you really didn't do it. But in this case, these people really did do it, and they continued to do it in front of everybody's nose while they sat on the board and robbed people, basically.
Richard, a few people it's the Hammocks, apparently.
Hammocks. I always forget the name, the Hammocks.
Nancy and John helped you out on that one.
Yeah.
I don't know why I draw a blank, and I always think about it when I'm coming up to this slide, and I still can't remember it. So fraudulent voting activities. This has been also ported over. This was put in 720 last year because of the hammocks, and now it's been put into 718. Okay. I'm not going to go through it in great detail, but it criminalizes certain voting activities that the hammocks were using to intimidate people to not vote or to not be allowed to vote so they could stay in power and on that board. So basically this list is, falsely swearing or affirming an oath, perpetrating or attempt to perpetrate, aiding in the perpetration of fraud in connection with the vote, preventing a member from voting, or preventing a member from voting as he or she intended by changing their vote or attempting to do that, menacing, threatening, and using bribery or any other corruption to influence the vote. That one, even in the old days, I know you guys got it. They'd always say, well, poor Mrs. Johnson, she's 80 years old. They came to her door at 10 p.m. and they screamed at her and she was afraid. So she voted the way they wanted. Those were not proper tactics before, but they really weren't criminal acts. Now, you need to be very careful of how intently you try to persuade others to vote your way. You can certainly advocate, vote this way. This is the best thing. But if you step over the line, you can be criminally charged. So I would tell you to be, respectful and professional and not get close to that line, because other people will say you did. Okay. And because they'll use it against you. Promising or directly or anything to give anything of value to buy the vote, basically. So you couldn't say, vote for me and I'll give you $10. This doesn't say you can't give them something of nominal value, like a button that said, vote for me, or that you couldn't hold like an election rally and serve donuts. Okay. That's not buying the vote. But if you literally said, vote for me and this will happen for you, of value, then that is illegal. The rest of these you can look at yourself: conspiring, doing all this fraudulent voting activity. Hurricane, I'm going to speed it up here just a little bit. Hurricane protection. This is an interesting new law. The former law said that all condo boards had to adopt hurricane protection specifications, and then owners could only put up that type of hurricane protection according to the specs adopted by the board. The statute also said the members could vote to make the installation, maintenance, repair, and replacement of hurricane protection a common expense and the obligation of the association. Okay. They could vote, make the board take that over. Not many of them did. Now that's been expanded. Now, on a majority vote of the total voting interest, you can take a vote that requires all owners to install hurricane protection as determined by the board. Where this would come into play is if you had let's say a high-rise condominium and, 80 of the units had hurricane protection, but 10 of the units did not, which was not an uncommon case because some people would spend the money and some people wouldn't. You could fix that now. In the past, we would fix that with an amendment to the governing documents. It was questionable whether you could do it. Now the statute clearly says a majority of the owners can vote to require all owners to put up hurricane protection at their own expense. So that is something that's new. They've just added the other side of the coin there. Also, another clarification here: if the association has to remove or reinstall hurricane protection, if it's necessary to perform maintenance on the building, that used to be an owner expense. You put up the shutters, but we have to take them down to get behind them to fix the wall. And then we would say, you got to pay to take them down and you got to pay to put them back up because they're your shutters. Now the statute says if the removal is necessary, then the association is responsible for that expense. So keep that in mind. That's a change. The statute of repose, it's like a longer version of the statute of limitations for latent defects, which are defects that could not be discoverable by reasonable inspection. Hidden defects, you now have 7 years and it runs from the date of turnover of the condominium. That was just a clarification of an earlier law they changed, but didn't change this law. So not really relevant in the grand scheme of things, but it's an important for condos to understand if they have a construction defect, they've got to deal with it under certain periods of time. SLAP suits. SLAP suits, this law has been in 720, the HOA Act, for many, many years in a slightly different version. They've now added it to 718. A SLAP suit is a strategic lawsuit against public participation. The idea is, I think traditionally came out of government. If you were complaining against the government and alleging the government or government officials were doing bad things or illegal things, and then the government turned around and, or even private industry, you were complaining against private industry, your employer, so to speak, or something, and that entity uses the legal system to file frivolous lawsuits against you, to intimidate you against trying to right the wrong that you perceive exists. Okay, it's called a SLAP lawsuit. Like, we're slapping you down. You're going to complain about us all the time. We're going to sick the IRS on you. We're going to bring all the power of government against you to intimidate you against exercising your right of free speech and your right to redress against the government. That's what a SLAP suit is. It's a defense against those kinds of suits. I'm not going to go into great detail here, but it's now been put into the Condo Act, which now means, it's been in the HOA Act for years, but it's stronger in the Condo Act. It basically now means, and I get this all the time, and I know Laura gets it, I know Shauna gets it, I know every board member gets it. There's that person or group of people in your condo community that are always complaining about the board, contacting every official in government, the building inspector, the code enforcement officer, the mayor. I've had them go to the governor. They're calling the state attorney and alleging bad acts against your board. And you're always getting investigated by these people. And it always turns out that none of that was really true. We often were asked to send letters to these people to say, hey, you're making these false allegations. You need to stop doing it. Cease and desist. If you don't, we're going to potentially bring a defamation action against you, or a lawsuit for tortious interference with a contract because you ran off our contractor, because you reported him to ICE because you thought he had illegal, unqualified immigrants. I don't know what the proper term is anymore, working on his crew. And so we would threaten you. Okay. And those letters rarely worked. They usually worked against the association, because then the person would take the letter and say, aha, look what they're spending your legal dollars on. They're trying to shut me up because I'm pointing out all the bad stuff the board's doing. We would write those letters frequently. Okay. Now we have to be very, very careful about writing those letters, because it basically says you cannot use association funds to try to intimidate people from exercising their lawful rights or their allegations that they in good faith believe are true. So this is really going to, in my opinion, going to shut down the industry of writing these cease and desist letters, because there are significant penalties under this new SLAP suit law. So I've kind of talked a lot on this. Just keep in mind, serving on the board and being the manager, it's a tough job these days with social media. We all know it. But you got to have a thick skin. You can't run to the lawyers anymore, really, and say, stop them from exercising their free speech, saying bad things about us. You just got to suck it up and ignore it and move on. I know that's easier said than done, but that's the best advice that we can give you in most cases. There certainly would be situations that might rise to doing something more, but they're going to be a lot riskier than they were before this law went into effect. Quickly, electronic voting. This now says if you offer electronic voting in your community, you can't take it away. Okay. You might have authorized electronic voting and I signed up for it, and now you decide, we don't want to spend the money. We don't like electronic voting. We're not going to do that anymore. You cannot take it away. Once you offer it to them, you get it. Ultimately, hopefully, electronic voting will become the norm and everybody will use it, because it saves money, it saves time, it saves accounting number errors. I think it's a good thing, but keep that in mind. If you don't use electronic voting today and you're going to vote to authorize it, you're in forever, because if whoever signs up, you can't take it away from them. But again, hopefully you'll get good participation and it will be a much more efficient process for you to use. Director conflict of interest. This just says if a director is at a meeting but says, I'm not going to vote because I have a conflict of interest on the subject, their presence at the meeting still counts towards the quorum. Okay, so just because they can't vote doesn't mean they're not there to establish the quorum. So it's just kind of a technical thing. Suspension of voting rights. They've now added to this law. The law previous used to say if you were more than 90 days delinquent in the payment of any monetary amount, the board could suspend your voting rights. Okay. Pretty simple, not very effective to get people to pay those monetary amounts, but you could do it. But guess what? And I'm looking at my notes here. The hammocks used this is what I'm told. I wasn't personally involved. The hammocks board used the suspension of voting rights law under the HOA Act to their advantage. Here's what they would do. They would put bogus charges. I was told this. I don't know. I believe it's true. They would put bogus charges on a person's account that they knew was against them. Wait 90 days and say your voting rights are suspended. So all the people that were trying to vote them out of office to make them stop doing bad things were suspended so that they weren't allowed to vote and the board stayed in place. So now, a couple of years ago, they made it harder to suspend voting rights, and now they've made it even harder still. So now to suspend a voting right in a condo, they got to be over 90 days, over $1,000. You got to give them 90 days notice before the meeting that their voting rights can be suspended. And there's also a 30-day notice. So suspending voting rights for non-payment of monetary amounts, very cumbersome, difficult to do. And if you believe it will result in those people coming to pay their debt, I guarantee you it will not. If they're not paying your association, they probably care very little about voting in your election or voting for the new amendment to, paint the clubhouse or something. So if you want to go through the exercise, it's complicated. You can do it. It's not going to result in a lot of money flowing in for those people. I'll probably have some questions, Laura, but I'm almost done here. So
Yeah, I'd rather just you go through and then we'll just do a rapid fire on you.
yeah, okay. This next one, creating a condominium with a multiple parcel building. It's a developer thing, not really relevant to post-developer turnover. They've increased the jurisdiction of the division of condominiums after turnover. They can now, after turnover, look into financial issues, fines, commingling of reserves, operating funds, conflicts of interest. They have much broader discretion to look into how the board is acting, which may be a good thing, maybe a bad thing, probably a good thing. They may now also, the division, if they discover what they believe to be criminal activity, they can report this to the state attorney to get you criminally charged. Further, the condominium ombudsman may attend board and owner meetings and committee meetings, even when not asked to. If they want to show up, they can show up. And the division has to be provided access to your website so they can look at it and see what you're doing. This final one is the MySafe Florida pilot program, which has been in place for single family homes for many years, which said if you harden your single family home by installing hurricane rated windows, doors, roofs, you can receive matching funds for the cost of that. They've now established this for condominiums as well, which if you are within 15 miles of the coastline, you can receive matching funds up to $175,000 per association. If you were going to say, replace all the windows with hurricane rated windows, and you went through the program's protocol and you qualified, you can get up to $175,000 in matching funds to help you put in those new windows. They want you to harden your building. So this is something you should look into. The question we've been receiving is, what if we just did this as a result of Hurricane Ian? We did it last year. Can we still apply retroactively? My understanding is the answer is no. This applies to go forward projects. So if you're thinking of doing these things, look into this program. It's initially funded at $30 million, but very likely it will run out of money quickly. But if it's as popular as the legislators believe it will be, they will likely refund it in the future, probably with more money, hopefully. So that's it for condos. Co-ops, the only thing they changed in the Co-op Act was that electronic voting law, 719 for co-ops. All this other stuff they didn't do for co-ops. But the electronic voting law, once you opt in, you can't take it away from them, is there. So, Laura, we got anything condo related, or do you want me to roll into HOA?
Shauna, yes, we,
Yeah.
yeah, yes, we do. Let's see.
Let's see.
Or
Somebody at
anything.
the very beginning, some of this might be hard to determine since we've gotten past certain areas, but somebody wrote, what are the new condo interior permit requirements?
As far
I
as
don't know.
renovations,
I don't know anything about interior permit requirements. I'm not aware of any. That might be something that the division will require us to educate people on, but I personally don't know of anything regarding that.
okay. What about where exactly does the SERS study need to be forwarded to in your city? I know it's different. I mean,
It's different. The statute talks about the local authority. I believe in Collier County, it's the business or the code enforcement or the the permitting department. Each
Yeah.
city is different. You're going to have to call your municipality and say where's is that.
yeah,
But
yeah.
they're supposed
The
to have.
city of Marco is requiring it to go in just like a permit. They're filing like a permit so you can find it online easily.
Okay. Okay.
Somebody had, I think they're talking almost like a rebate, but somebody wrote on kickbacks, if a cable company offers the association a monetary value of $100 per unit and a board member has a unit, is that considered a kickback?
That's a great question. That's not what the law was intended, because that money is going to go into the association's coffers for everybody's use. So no. Could you interpret it that way? It certainly feels like a kickback, but it's not going to a single board member. So no, great question, but no, that would not be considered a kickback.
And then going back to electronic records, if an owner doesn't have access to a computer, are you still required to print those out at the office and have them available?
Another great question. I've had this before. The law doesn't say, I read what the law says. It doesn't say, but if the person is not internet savvy or doesn't for whatever reason use the internet, doesn't want to use it, doesn't trust, whatever. It doesn't say you have to accommodate them in another way. It doesn't say that. Now, should you reasonably consider doing that? Yeah, I think you probably should. But I've also had recently, funny story, is a person that is computer savvy, but he or she, I won't name them, is that person who is the serial records requester and is kind of belligerent. And he or she insists on coming in the office to look at the records. And we're like, we don't want you. The management, we don't want this person in the office. And they asked me, can we simply refer him to the website? I said, yeah. He said, well, he doesn't use the website. He doesn't want to use it. I said, tough. That's not what the law says. So you're not required to accommodate them, but I think you reasonably should consider doing so if they're reasonable and there isn't some other overriding reason not to. Alternatively, you could say, hey, come by the office and we'll show you how to use it on our computer, or get a friend or a neighbor that can help you. Again, if it's reasonable, I wouldn't make a big deal out of it. But if it's that person, refer them to the website.
If a condo rules require a 30-day minimal rental and 55 and over, what records need to be available? Is it enough for an officer to certify that the person meets those requirements without keeping license copies and records?
You have to take a census this condo co-op, any over 55 or over community, you've got to take a census every 2 years to confirm the person's age is 55 or over for the qualifying. You need one person 55 or over in at least 80% of the units. You can accept different forms of proof, and people are different. So you could accept a driver's license. You could accept a passport. You could accept a birth certificate. You can even accept an affidavit sworn under oath, in my experience, by the person that says, I am 55 or older. I don't know if you could take something from someone else that supports that the person. I think it has to be from the person. I don't know if an officer could say, I know Mrs. Johnson is over 55. I don't know if that's going to work. I think you're going to need something from the person. They either sign an affidavit or they provide the proof, but it doesn't have to literally be a birth certificate or a driver's license. So I'm going to roll into HOA here. There's not as much, and then we'll have more time for questions.
Yep.
but as we go. So the website, just like condos, HOAs never had a website requirement. Condos had that website requirement a couple of years ago, 150 or more units. That's now been reduced to 25 or more units. Now HOAs under 720 are required to have a website that complies with the certain requirements of the statute, and you're required to put certain documents on that website by January 1, 2025. So that's like 4 months. So if you're 100 or more parcels in an HOA, you got to have that specific website. You got a little bit of time to do it. If you're under 100 parcels, you don't have to have you can have it if you want. You don't have to have it.
And just to be clear, Richard, Facebook does not suffice for that, right?
No, it has to have a protected portal provision and certain other requirements. So Facebook, no. Okay, this inspection of records is basically the same law that I talked about for condos. If you knowingly, willingly, and repeatedly don't provide access to records twice in the 12-month period, you've committed potentially a misdemeanor. If you destroy records, you've committed a crime. If you knowingly, willfully refuse to produce records with the intent to avoid escape, detection, arrest, or trial, you've committed a crime, okay? So these are all things related to intentionally preventing people from getting records, destroying records, or refusing to release records if you're trying to avoid, getting, having bad stuff, come back at you for it. So same stuff as the Condo Act. Subpoena of records. This now says if the association receives a subpoena from law enforcement, you have to comply within 5 business days. Frankly, when we receive subpoenas from law enforcement or even civil lawyers in cases, you got to comply. Okay, so this is not anything different than you were probably already doing. There is a part here that says an association must also assist law enforcement agency in the investigation to the extent permissible by law. This would come up from time to time when there might have been a crime and the sheriff would come to the association and say, I want the front gate video security tape for May 30th. And the HOA would, or the condo would call me and say, we have to give it to them. And I said, look, it's law enforcement. I think you should give it to them. Can you legally, we could create a scenario where you could probably not give it to them. But I always felt like we're doing, the civic good. So now you've got to, within reason, you've got to assist them in their investigation, which I think most of us were already doing, unless it was the board being investigated. And then they would say no. Okay, this next one is, again, HOAs forever, or for a long time, have been required to do a year-end financial report, just like a condo, just like a co-op. Within 120 days after the end of the fiscal year, you got to do an audit, a review, a compilation, or an internal review of receipts and expenditures based on your level of revenue for the year. If you were above 500, you had to do an audit, or 500 or more, you had to do an audit. 350 to 500, a review. 150 to 300, a compilation, and below that, and you could waive down. Okay, that's been the law for a long time. This now says, regardless of the amount of your revenue, if you're 1,000 or more parcels in your HOA, you have to prepare an audited financial statement. I have examples of really large HOAs that really have no common area to take care of. So they might have a budget well below 500 grand. Their budget for the whole year might be $150,000. So they were never required to do an audit. Now it says, even if you're below the threshold to do an audit based on your revenue, you still got to do an audit if you're 1,000 or more parcels. But in my understanding of this new law, you can still waive the audit. You can still have a majority vote of those present voting to waive down the audit. But it's something to keep in mind. Again, you can't prepare financial statements for consecutive fiscal years. Same thing for condos. You can't waive for 2 years in a row. Debit cards, basically the same law. You can't have a debit card, but if you do and you use it for a bad purpose, you commit theft. But the real takeaway is HOAs can't have debit cards, so don't use debit cards. Requirement to provide an accounting. Okay, this is interesting. And I think this probably came out of the Hammocks thing as well, where they would put false charges on your account and then declare you illegal to vote. So they could stay in office and you couldn't vote them out. This new law says if a homeowner in an HOA requests for an accounting, that meaning show me my account ledger with all my debits and credits on it for my account, you have to provide that within 15 business days, not calendar days, business days. You got to provide them that accounting. If you don't provide them that accounting, and on that ledger was a fine that you alleged was outstanding, that fine is now waived. So if you're going to stack up a bunch of bogus fines on people's accounts, not that you would do that, but if you did, and I request an accounting and you don't give it to me within 15 business days, all those fines go away. So just keep that in mind. Really something your management company would keep on top of. Now, they can't request an accounting more often than every 90 days. We talked about that. Let's see. Which are more than, yeah. Okay, so we've covered that. So now director certification. This is the HOA version of the new director certification law. Okay. First of all, they've done away with the certificate. For condos, you got to sign the certificate and take the course. For co-ops, you can sign the certificate or take the course. For HOAs, there's no certificate anymore at all. You got to take the course. Okay. It's good for 4 years as opposed to the 7 years for condos and the forever years for co-ops. Again, 3 different levels. You got to take it every 4 years. The department has to have approved curriculum, which they're establishing or have established now. And so you got to take that certification course one time every 4 years, et cetera, et cetera. In addition, just like for condos, that they have a 1 hour CLE requirement every year, for HOAs, they now have a 4 or 8 hour continuing education requirement every year. So if you have less than 2,500 parcels in your community, 2,500 doors, less than 2,500 lots, you have to take each board member has to take a 4 hour continuing education course every single year. Whereas condos, you take 1 hour. For co-ops, you don't have to take any. If you're more than 2,500 parcels, you got to take an 8 hour course every single year. Again, while I think education is good, while I think if you're going to serve on the board, a good board member will educate themselves without being told to do so. But, you know, I can see a lot of people saying, look, I'm not going to take 8 hours of my day to go to these courses. I'm just not going to do it. It's not what I want to do. So I don't want to be on the board. I think this will possibly, lessens people's desire to serve their community on their board because they don't want to take these courses. Okay. Kickbacks, same thing. They've defined kickbacks in there. Again, if you're charged with a criminal act and you're on your HOA board, you're removed from the board until the charges are resolved. Again, same thing for condos. These are new changes for ARC and ARB, Architectural Control, Architectural Review Board. A couple of things here. First of all, you have to treat everybody the same. The standards have to be published and the standards have to be uniformly enforced. That's a given. You probably should have been doing that anyway. If you, let's see. Okay, now, I don't see it in here, but another part is when you deny the ARC, you deny their ARC application, although you were probably doing this before, you specifically have to do it now. You have to say, we're denying your ARC application because it violates ARC provision J, which says houses can only be painted the colors shown on this palette. Your proposed color is not on the palette, therefore denied. You basically have to cite to the section of the ARB guidelines that you're relying on to deny the application, which in good practice you would do before, but you definitely have to do it now. Now, where this also comes up, most ARC provisions in HOA says, let's just make up an example. If I turn in a complete ARC application and you don't approve it or deny it within 30 days, it's deemed approved. That's a default provision contained in many HOA ARC guideline documents. But I've seen the reverse. I've seen the reverse where it says, if we don't approve or deny within 30 days, it's deemed disapproved. Okay. If that's what you've been following, because that's what's in your documents, you can't do that anymore. You have to now follow this law that says you disapprove it for a specific reason and which section. So I don't believe the default disapproval, because we didn't do anything for 30 days. I never liked those anyway. I don't think you can do them now. You have to give a reason. So keep that in mind if that's how you've been doing it.
Hey, Richard, for the HOAs on the ARC request, if it's denied, does the board need to establish an appeals committee for the member to appeal the ARC
There's no
denial?
legal obligation to have an appeals committee. Some documents create that obligation. Some boards will just allow it, but the statute does not say you must allow an appeal. Now, anybody can say, I want to appeal to the board, and the board can say, we don't take appeals, nothing. But the statute doesn't give them an automatic right to appeal.
Okay.
Okay, now, an association or ARC a committee may not enforce or adopt a covenant, rule, or guideline that limits or places requirements on interior of a structure that is not visible from the parcel's frontage or an adjacent parcel or common area or community golf course. What this basically means is if your ARC guidelines required you to get approval to do things inside your home that are not observable from the exterior, you had to get approval. Now it says you can't require that, which, and we're going to get into this whole issue of Kaufman language in a minute. So I'm going to explain that, but let me get through this one. That kind of makes sense if it's a single family detached home. If I want to get new cabinets in my kitchen, in my single family detached home, or I want to move a wall, why do you care? Okay, that makes sense. Okay, so you shouldn't have jurisdiction over what I do inside my home. Makes perfect sense over a detached single family HOA home. Doesn't make sense when you're an attached villa HOA. Some of you probably live in these. It's an HOA under Chapter 720, and it's like a brownstone where they're all attached, and you own the slice of your building, but your roof is a common roof. Your walls are a common wall. Your boundary wall is into the next home next door. Should the association have authority like a condo over that? I believe they should, because if I want to remove a structural member inside my villa attached single family home, that can have a significant effect on my neighbor's home, which is attached to mine. So I don't think this was well thought out, in that not all HOAs are single family detached homes. And I think this might need some work. The second thing is the ARC no longer has approval over air conditioning, refrigeration, heating, or ventilation systems if the system is not visible from the parcel's frontage, an adjacent parcel, or an adjacent common area community golf course. Basically, you can't tell me what kind of air conditioner I want to put in my single family home if you can't see it, is what this is kind of saying here. Whether these laws apply to you in an HOA based on when your governing documents were recorded is an issue that you might have heard of called Kaufman language, which I'm going to explain in a minute. But for now, this is, and so not these laws that I'm talking about that are overriding certain things you've been doing in your community may or may not actually apply to your particular community based on when your governing documents were recorded and whether or not that recorded document incorporates future changes to 720 or says we follow 720 as it existed in 2020 when we recorded the declaration. And I'll explain that more in a minute. Okay, more on ARC or ARB. Okay, this is what I talked about, which I couldn't find before. Number 11, you now have to provide written notice to the parcel owner stating with specificity the rule or covenant which the association or committee relied on to deny the request. Okay, which you should have been doing already, but now that's required. Hurricane protection, just like condos and co-ops, you now, even in a single family home neighborhood, the board must adopt a standard for hurricane protection, meaning it has to match the color of your home. It has to be rolled down. It has to be metal, whatever. If you don't adopt a spec, they can use anything they want. Okay, they can put up anything they want. Okay, items in the backyard. This is where I'm going to get into the Kaufman language a little bit. This law is an amendment to the same law that was adopted in 2023 as part of the Homeowners Bill of Rights. Okay, And that law that was effective in July of 23 basically said, if your documents prohibit certain items from being placed in the backyard of your home, such as a shed, very common, no sheds are allowed on the lot. That's a very common provision, right? No sheds allowed. Let's just use that as an example. If your documents said that, the law in 2023 was changed to say, in addition to sheds, they said AstroTurf. Basically, if there's anything that your document prohibits in the backyard, that cannot be enforced as long as the item that's in the person's backyard cannot be seen from the front of the home, standing on the street, cannot be seen from the adjacent parcel, cannot be seen from another parcel like at the rear of the lot. So basically, if you had a fence around your backyard, 6 foot high, anything that couldn't be seen because the fence was there, or maybe you had a really thick hedge, the statutes was changed to say, you can't stop me from putting anything I want in my backyard if you can't see it. Okay, that's what it said. They've now expanded that law. They've added to it. They've added vegetable gardens if you can't see them. You can't prohibit them. They've added clotheslines if you can't see them. They can't prohibit them if from the parcel's frontage, adjacent parcel. They've now added common areas and golf courses. So basically, so that's what the law says. I'm going to get into the Kaufman language in a minute in another more relevant statute, but it pertains to what I'm talking about here. Fines and suspensions, they've added a lot to the fines and suspension procedure in the HOA statute. Why they didn't also add the same thing to the Condo or Co-op Act, which also allows for fines or suspensions, I don't know. So now the procedure is different. What they've done for HOAs, first of all, you have to hold the fining committee or suspension committee hearing within 90 days after issuance of the notice. So if the board imposes the fine or suspension, they have a right to a committee appeal hearing with 14 days notice. You now have to make sure you hold that committee hearing within 90 days. Clarifies that the hearing can be held by telephone or other electronic means. Within 7 days after the hearing, the committee must send written notice of the decision of what the committee's decision was. And then it goes on to say, if it's a, you have to tell them what they can do to cure the violation. And if it's to pay the fine, you can't make them obligated to pay the fine any sooner than 30 days after you send them the notice. There is another section, there's another part of this that's become very tricky, okay? What this new statute also says is, if the board imposes the fine or suspension, and before the appeal hearing, the committee hearing that's at least 14 days away, the person corrects the violation, then the fine or suspension goes away, okay? So it basically, let me give you an example. If the board says, we're imposing a fine for every day hereafter that you don't cut your grass because your grass is too high, it's $100 a day. By the way, your fining committee hearing to appeal this or to have them approve or disapprove it is in 3 weeks. If I show up at the fining committee hearing and I say, here's a picture of my house I took yesterday, I cut the grass, then there is no fine or suspension. It goes away. Kind of makes sense. You know, your intent with fining and suspension is to try to get people to follow the rules. You're not really doing it to make money, and that's not really the intent. So that kind of makes sense. Where this, can I correct it before the hearing gets a little tough, is what if the fine or suspension is imposed for something that's really not correctable, okay? Like I ran over the stop sign. I broke through the front gate, okay? I can't correct that because it was done. Okay, I get it. It's a non-correctable fine. It's a non-correctable violation. So I think your board's going to have to make that distinction. Where it gets to be a gray area is and again, we know these people are out there. Let's say it's, don't park your truck on the grass. We're fining you for parking your truck on the grass. But before the fining hearing, I put my truck in the driveway. So I say I corrected the violation. Then after the fining hearing, I go park my truck on the grass. And then before the next fining hearing, I move it to the driveway. I corrected the violation. This ping pong effect that these people will do just to play games. How do you deal with that? Okay. Is that a correctable violation? My early solution to that, which I'm not sure is going to work, is make the fine prospective, not you parked yesterday on the grass. Make the board impose the fine that says every time you park on the grass after today, it's $100. And then I go park on the grass. I'm not sure that's a correctable violation. I don't know. Is that a way around? And then I move the car? I don't know if that's going to work, but that's what I'm toying with in my mind. Is that prospectively imposing the fine? You've already done it. You did what we told you not to do. Therefore, you can't correct the fine. I think that's a reasonable argument. Is that going to work? I don't know. But this correctability of a fine is going to be a difficult thing to deal with for boards, managers, and the like. Couple of more things on fines. It now says if you have a rule about when you can put your garbage out, like, no sooner than 6 a.m. the day of, and you got to pick it up 6 p.m. the same day it's picked up, there's now a 24-hour grace period on either end of that. If it's at the end of the driveway or the curb, they have a 24-hour grace period. They can put it out 24 hours ahead of the time you're allowed, and they can leave it out 24 hours after the time allowed, and you can't fine them. Okay, that's what it says. Well, what if I remove it? I checked the statute. It literally says at the curb or end of the driveway. So theoretically, if someone pulls it off the curb or the end of the driveway and sets it up by the garage door, they don't get the 24-hour grace period because it's only at the curb. Kind of interesting. Also, leaving holiday decorations up. If you have a deadline for leaving holiday decorations up, they must be down by January 15th, let's just say, okay? You now have a week grace period before you can impose a fine. So you have to tell them, hey, the deadline to take down your Christmas lights or your holiday lights was January 15th. They're still up. You can't fine them. They have another week to do it. Unfortunately, they didn't define the term holiday. So theoretically, it doesn't necessarily mean a recognized federal holiday. Under certain circumstances, I believe every day of the year is a holiday for somebody, either religious holiday, a non-religious holiday, whatever. I bet we can find a holiday for some group for every day of the year, and you could claim that's all part of my group. So again, lawyers think their way around the laws, which sometimes is not a good thing.
Hey, real quick before we leave fines, Richard, can
Yep.
any owner attend a fining hearing?
That's a good question, and I've had it before. I don't believe the statute does not say owners have the right to attend fining hearings. None of the statutes say that. What the statute says is certain types of committees, and the fining suspension committee is a committee, have to be run the same way as a board. But that basically says if your documents require it, or if it's an ARC committee with final authority to make the decision, or if it's a committee to work on the budget or to spend money, those are committees that have to be operated like a board, which means notice, right to attend. The fining committee doesn't do any of that. So I believe unless your governing documents required it, you could prohibit owners from attending fining committee hearings. And I got to tell you, in those instances where I've had owners attend, it kind of gets messy because they want to talk. The person brings their supporter of 50 residents and it gets out of control. So I don't know that works best anyway. But no, you're not required to allow owners to attend.
Yeah. And back to the holiday lights with the grace period, is that the same for condos and HOAs, or that just the HOA specific?
Just HOA. And let me clarify on the fining committee. The Condo Act says all committees meet like a board unless your governing documents say they don't. So if your governing documents are silent on how committees are to meet, then your fining committee in a condo would have to meet like a board, which means open, in my opinion. Conversely, the HOA statute says unless your documents require it, no committees meet like the board except the ARC committee and a committee that has the authority to spend money. So in that case, if your documents were silent, you could keep the condo committee or the fining committee closed. You need to talk to your particular lawyer to find out which it works for you. Voting fraud is a crime. We're not going to talk, same thing we talked about before. Okay, now here's where I'm going to get few minutes on this Kaufman language thing. This is the statute change that is getting a lot of press. Okay. First of all, it only applies to HOAs under Chapter 720. Okay. I got people coming to me saying, aha, my condo can't let me not park my commercial. I always pick on this company, nothing against this company. My Truly Nolan mouse car, they can't prevent me from parking it in my condo driveway. Yes, they can. This law does not apply to condos, does not apply to co-ops. It applies to Chapter 720 HOAs, maybe to your community. First of all, what it says is a property owner or tenant or guest or an invitee, which would be a business person coming to see you, of the property owner cannot be prohibited from parking his or her personal vehicle, including a pickup truck, in the driveway or in any other area which the property owner or the owner's tenant or guest has the right to park, like guest parking or on the street in your community. Okay. Also says that the homeowners association documents, including the declaration, etc., may not prohibit, regardless of any official insignia or visible designation, a property owner, tenant, or guest from parking their work vehicle, which is not a commercial vehicle as defined in Chapter 720, in the driveway. What this basically says is, if your HOA documents say you can't park trucks in the driveway, they can only be in the garage, or it says you cannot park commercial vehicles in the driveway unless they're covered up or they're in the garage, this law says those restrictions are unenforceable. That's what this means, okay? Does this apply to your community? This goes back to the issue of Kaufman language. Kaufman language is a condo case from, I believe, 1978 or so, called Kaufman versus Scheer. I believe it's S-H-I-R-E or maybe S-H-E-R-E. You can look it up. It's a very famous case. What it basically says, in short, is this. When you record your declaration of covenants, condo, HOA, whatever it might be, on the day you record those covenants, the law in effect on that day is the law that controls you, unless, one, the specific law is changed and made expressly retroactive, which is rare, or two, your governing documents say we will follow the law on the day we record these documents and as amended from time to time. That language, as amended from time to time, is what's referred to as Kaufman language, because the Kaufman case said if your document said you incorporate the statute on the day you recorded it, but you also said, and as amended from time to time, then you are also controlled by all future amendments to that law. Okay? So if your documents do contain Kaufman language, as amended from time to time, this new law will override your restriction against parking trucks in the driveway or commercial vehicles in the driveway. That law will override your documents. However, if your governing documents do not contain Kaufman language, then arguably, and I think pretty strongly arguably, you cannot retroactively impair my declaration by overriding it with your new law, because I don't follow your new law on that substantive change. There's a whole other analysis about substantive versus procedural. You need to talk to your lawyer about that. But effectively, whether this law applies to you is a case-by-case basis, community-by-community document basis. You got to go to your legal counsel and ask them, do our documents contain Kaufman language or not? Does this law apply to us or not? Without being flip or arrogant, if your lawyer says, what is Kaufman language? You need another lawyer, because if your lawyer doesn't know what Kaufman language is, and I'm not saying maybe a brand new lawyer, it's a seminal case in condo and HO and community. It is a core case that you know and you need to know because it affects a lot of things. Doesn't come up all the time, but certainly is on the forefront now. So don't swallow this whole and say, we can't stop trucks in the driveway. You need to look at your documents. You need to see if they contain Kaufman language. So maybe the law applies, maybe it doesn't. In any case, that also goes to those ARC things that I talked about to some extent. Does Kaufman language include the new law or not? It's an analysis you're going to have to do. Additionally, here's another one. A property owner cannot be prevented from inviting, hiring, or allowing entry to a contractor or worker to work on their exclusive parcel just because the worker or contractor is not on the association's preferred vendor list. So if your HOA has a preferred vendor list and I want to use a contractor to work on my roof that is not on your list, you cannot deny me the ability to do that. I get that. The second part is a little bit trickier. It says the association may not require a contractor or worker to present or prove possession of a professional or occupational license to be allowed entry onto a property owner's parcel, which means, and this is very common, I want to put on a new roof on my single family home. Part of the ARC's guidelines say you got to show that your roofer is licensed with a professional roofing license and an occupational license. This says we can't require that. Okay. I get it if it's a single family home. I get it. You want your Uncle Bob to work on your roof that doesn't know anything about roofs and the roof caves in, hurts you and your family. That's the risk that you chose to take. But let's go back to the villa attached common roof community. You don't think an HOA should be required to only allow a licensed roofer on that common roof building just because the slice of that roof is your own property? That doesn't make any sense. So maybe this law will get tweaked a little bit, but that's what it says for now. Oh yeah, you can prohibit operating a commercial vehicle. There is a commercial vehicle statute, chapter 320. You can prohibit, regardless of the Kaufman language, you can prohibit commercial vehicles as defined in chapter 320. Well, guess what a commercial vehicle is in chapter 320? It's basically a vehicle, I believe, I might be getting it a little bit wrong, that weighs more than 25,000 pounds, I believe is what it is, and has like 6 axles. It's like a semi truck. Okay. So, it would not, your truly Nolan mouse car is not considered a commercial vehicle under this statute. Okay. We're just about finished here.
There's a number of people who are asking about motorhomes. Are those considered, where do those fall?
Well, I've had that too. The statute says personal vehicle. Okay. Personal vehicle. I've had people claim that their personal regular day vehicle is their motorhome. Okay. So if that's their personal vehicle, arguably you can't prohibit it. Okay. Which, kind of crazy, but I've had people say that, yeah, I drive my Winnebago to work, not a lot. It's more likely like the Sprinter van or something that, person will say, no vans, but it's my personal vehicle. So that's a great question. I don't have a yes or no answer.
And
Hey, Richard, going back to the ARC not requiring with single family detached homes specifically, I understand that the license they don't have to have, but can the ARC require proof of insurance or?
Doesn't mention insurance. So yes, you could still require insurance. Because the statute just says professional or occupational license. We're almost done here and then we'll have plenty of time for more questions. Fuel sources. This basically says an HOA cannot preclude the use, and this isn't a typo, the use of types or fuel sources, which is just awkward to read, of energy production, which may be used, delivered, converted, or supplied by entities to serve customers within the association that are authorized to serve, which basically means if your HOA said you can't use natural gas in your home and have it piped to your home, for whatever reason, but TECO or whatever the other natural gas suppliers are in the state has a jurisdiction to supply that to your home, you can't prohibit them from allowing it for using. Likewise, the HOA may not prohibit the use of appliances, including stoves or grills that use those authorized types of fuel sources. Okay. This would also go back to like whole house generators with a large buried propane tank. If you would purport to want to prohibit that, if it's lawful and it's by a lawful supplier, you can't prohibit it, is what it basically says. Okay, finally, compounded interest is prohibited for late assessments. I don't know anybody that was compounding interest. We've always advised simple interest, 18% max. But if you were compounding your interest, it's no longer allowed. First responder vehicle, the statute a couple of years ago was changed to say that if your documents prohibited certain types of vehicles parked in the driveway, you can't prohibit law enforcement vehicles. So if I want to bring my sheriff deputy car home, you can't stop me. It's now been expanded to include first responder vehicles. So it's going to be much more than just law enforcement. It will be other first responder, which is defined elsewhere in the statute. The final two here for HOAs, and then there's a little bit on management, and we're reaching the end here. On or before October 1, 2024, which is basically 20 days from now, 21 days from now, an association must provide a physical or digital copy of the association's rules and covenants. That's what it says, rules and covenants. But what about the bylaws and articles? I don't know. What about the ARC guidelines? It says rules and covenants. You have to provide it to every member of the association, and thereafter must provide a copy to every new member. If the rules or covenants are amended in the future, then the association must provide an updated copy. But then it says the requirements of this law may be met by posting a complete copy of the rules and covenants on your homepage of the association's website. So the easy way to comply with this is I would say not just the rules and covenants, I would put all governing documents on your, it says homepage, which I think means front page.
Right.
Put it on your website, you've complied with the law. Okay. Any amendments, put them on the website, you've complied with the law. MARTA revitalization, if this pertains to you, they've just changed the department that has to approve your Marketable Record Title Act revitalization. Not going to get into that in great detail. No changes here. And then briefly, there was a lot of changes for Chapter 468, which pertains in part to community association managers and management companies. I'm not going to go through all of it, but there are a couple of changes which are, I think, good.
Mhm.
One is that if the management company is terminated or instructed to turn over the books and records, they have to do that within 20 days of the written request. And if they don't, they can be subject to a penalty of $1,000 per day, up to 10 business days for failing to turn over the books and records. They can retain certain records to complete the necessary financial report. But I think this is good because I know the managers that are on here, and I know Laura and Shauna, and I know board members deal with this all the time. For some reason, when a management company quits or gets let go and the new management company gets hired, there's always this battle. Or a lot of times, the new manager will say, I can't do my job because the old manager won't provide me the record. Sometimes that's true. Sometimes that's an excuse. Then you'll go to the old management company and they'll say, I mean, this never happens with Castle, and I'm not being facetious, but it does happen. The new manager can say, I've given them everything. Okay. So there's back and forth about you did or you didn't. Now, good management companies like Castle, they cooperated. Look, you get hired sometimes, you got to deal with the outgoing manager. You're going to get fired sometimes or let go. You're going to have to deal with that manager. There's no reason to battle it. You're going to be on both sides of that if you do more than a year in this industry. Okay. Lawyers deal with it. Landscapers deal with it. It's just a fact of life. So don't be obstinate with dealing with the incoming person replacing you. It's not fun. It kind of sucks. Sometimes it's completely unfair, but guess what? You're going to be on the other side of that coin someday, and you're going to have to deal with that manager on the reverse, and hopefully they'll treat you as you treated them. That's the idea. Now there's real teeth in not cooperating in this $1,000 a day fine up to 10 business days. Couple of other things. This is all about conflicts of interest. The management company always had to disclose conflict of interest. If they had an affiliated company, like they're a management company, but they also provide landscaping services through another company that they are affiliated with or they own, the management company always had to disclose that. I mean, or should have. Like, hey, I'm promoting this landscaper. By the way, it's our company. Okay, that's to avoid a conflict of interest. Now it's spelled out much more expressly. And what the big takeaway here is what this says here in number 2. If the management company is promoting you hiring an ancillary affiliated service, landscaper, I don't know what else there are.
Well, yeah.
Okay. And that goods or services are $2,500 or more in value. you have to get at least 2 more non-affiliated bids. Okay, so it's kind of like competitive bidding, but it's not based on the old competitive bidding statutes. It basically says the management company says, hey, here's who we think you should use for landscaping. It's ABC Landscaping. By the way, we own the company. And the landscaping contract's more than $2,500, then the management company or the board has to go out and get it says multiple bids, which I interpret to be at least 2 more bids from non-affiliated landscaping companies. If it's a competitive price, I don't think this should be in anybody's, hurt anybody. I think it's a good idea, I guess, but it's just something to keep in mind. I think that is, here's a funny one. This is the last one, basically. A community association manager must now attend in person at least one member meeting or board meeting of the HOA annually. Okay. First of all, if your manager or manager company was not attending at least one of these meetings or both of them,
For all of
they're
them.
probably the happiest manager company in the world because they never had to go to meetings and they probably love you. Okay. I'm being facetious, but this basically says the manager has to show up at least one board meeting or one membership meeting a year, one or the other, not both. What it says, attend in person. Now, I don't know if that means physically there or they could be on Zoom like we are today. I think in person to me probably means physically there. Okay. Additionally, on your website, you have to post the management company contract, the summary of their duties, and you have to update the association and its members within 14 days after a change to such information. So you have to send your website. Our manager is Shauna. Shauna is no longer in the actual day-to-day management. I'm sure she's happy with that. But you have to say, our manager is Shauna, and this is Shauna's office hours, and this is how you contact Shauna. And then when Shauna, left and they replaced it with Laura, you have to say within 14 days, hey, our manager now is Laura. This is her contact information. This is how I get a hold of her. So that's what you got to do. That's more in the MySafe Florida. Okay, so that hour and 45 minutes. So a lot there. This is available on our website. It will also be sent out by Castle with their email.
Yep.
That's it. So if you want to stick around for another 15 minutes, I'm happy to do so, whatever you all want to do.
Yeah, we have a ton of questions. I have a quick question going back to that being required to attend a board meeting. Now we're full service management, so our managers are required to attend or should be attending all the board meetings anyway. It's included in the management fee, but I do know that there's a number of management companies out there, especially companies who specialize more in the portfolio sector, that they actually will charge for the manager or somebody from the manager company to attend a board meeting. So I don't know, like in the law, can they do that if it's required now that a manager must attend at least one board meeting? Can they charge the association for that?
Great question. I suppose they could say, look, well, first of all, you're right. The law says they have to attend, okay? And that's in the management statute. Does it say they can condition their attendance on being paid? I suppose they could say, we will comply with the law if you hire us, but we also want to be paid. But, I don't want to say anything bad about management company, but I mean, attending meetings is part of the gig. I get it saying, hey, we're not going to attend one every week, or we're going to charge more, or we're only going to attend 2 a month, or I get all that. But if they're not attending at least one a year without being paid extra, I don't know. That's a great question. I don't know. I guess they could condition, hey, that's what our contract says. So if you want it for free and it's not built into the management fee already, which I would think it would be, go get another management, I guess.
Yeah. And one more question that this came up a lot throughout the whole presentation back in Condo. A lot of people are still asking about the meetings. Is it required that they still do in-person meetings or give that option, or can it be strictly virtual now?
Yeah, that's a good question. Here's my take on it. I think most attorneys feel the same way. You cannot have a pure virtual meeting with no physical location that even that virtual terminal would be at. Because if I'm a person that says, I don't have a computer, I don't have a phone, I don't do it, I'm still entitled to attend the meeting. So in my opinion, you still have to have a physical location, okay? Like the management company. Who is at that physical location? You may have no one there but the manager and a monitor that is connected to Zoom like this. But in my opinion, you must still have a physical location for a person to go to, but no one has to be there except a monitor that they can look at everyone else online, that they can hear and they can speak at. That's my opinion on that. So yes, you cannot force them to only attend virtually, in my opinion.
All right, we have 60 plus questions here, guys. We're gonna try to, get to as many as we can. So we apologize if we don't get to your question, and you can always reach out to us or reach out to Richard offline.
Yeah, forward them to me,
as
and,
well.
we write a column in the several newspapers around the state, so we might put your question in there without disclosing who you are.
Okay. Well, you want to start rapid firing there, Laura?
I know, I'm looking through trying to find some questions. So, you have answered 53 questions, Richard,
Yeah.
throughout this. We have so Tara asked, we have a sensitive situation with a resident that we need to hear their side of the complaint, and we need to decide if we are going to suspend their amenities. So this maybe go back to finding. The conversation needs to be private, but then voting can be public. Can a quorum of the board be present to hear the resident's defense in private, or does that meeting need to be public and posted?
In my opinion, it cannot be a closed meeting. You can close a meeting 2 times. The lawyer is present to discuss proposed or pending litigation, which is covered by the attorney-client privilege, or the meeting is without the lawyer necessarily to discuss a personnel matter, which is something to deal with your employee or your management company. The scenario described is neither one of those. So the answer is no. If a quorum is there, in my opinion, that's a meeting, has to be open. The way to get around it would be have less than a quorum of the board there, and it's not a meeting. And then you could have that subcommittee report to the remainder of the board individually. Or I suppose you could, well, that's the only way around it that I see.
There's a couple of things here regarding official records. One being going back to opening questions, allowing homeowners to do questions quarterly or at least quarterly. Are homeowner questions part of the official minutes?
Good question. No, you don't have to. The official minutes are when the meeting was called to order, establishment of a quorum, who was there for the quorum on the board, proof of notice, motion, second, vote, adjournment. That's all that needs to be in the minutes. You do not have to put, I say this all the time in the seminars, when the person stands up with their 5-page letter on how horrible the board is and says, this will be on the record, it will be in the minutes. You do not have to put any of that on the record. You don't even have to put in the minutes, Mr. Johnson stood up and told us we were all going to, a bad place because we're a horrible board, just like he does at every other board meeting. None of that has to be in the minutes.
And then on that
If
note,
she
there's
turns
another
in
thing.
a document, if they read their statement and they hand it, it doesn't have to be attached to the minutes, in my opinion. It's an official record that goes in a file somewhere that somebody could look at it.
Okay, and then another thing that kind of goes into that, and this gets asked a lot as well, and we're not a big fan of this, so we'll see what your thoughts are on it. Recordings of meetings by board, are those considered official records? And should we be recording our board?
Yeah,
meetings?
it comes up a lot. My opinion, and I think the prevailing opinion is, if you record the meeting, you should do so for the sole purpose of being able to properly transcribe the minutes into a written form. And when that recording has been used for that purpose, you should destroy the recording. During the period of time the recording is in your possession and before you've created the minutes, that recording would be available to other owners, in my opinion. But once you destroy it, if that's your policy, it is obviously not available. So for a short window there, if you have the recording, I believe that would still be available. But my advice is, if you need to really record the meeting to properly do the minutes, if you really need to do that, do it. But I don't know, and you guys can tell me because you're the ones that take the minutes often. Do you really need the recording if you're kind of good at doing minutes? Jerry made a motion, Bob seconded it. The vote was 3-2. Jerry, Bob, and Sam were 3. You know, so keeping the recording around forever. I just answered this question yesterday for a client. It's used against you more than it's used positively. It's a place for owners and the owner's lawyer to go back in time, listen to that meeting, and say that you didn't do what you said properly, and they just make problems using it. So I don't think, if you can get away with not recording the meeting, don't record it. If you have to record it, then only keep it for as long as you need it to make the minutes.
Yeah.
There's a question on how long should the short version of financials be available on your website? And I would like to encompass official records of the association. How long should they be posted on the website?
Well, the statute requires different records to be kept for different periods of time. Sometimes it's forever, sometimes it's for 7 years, sometimes it's for 1 year. So it depends on the record. And I believe there's even well, it depends on the record. I have to know what the record is, and I don't know what the financials, I think financials are 7 years, I believe. I don't know.
Yes, 7 years. There's so many good questions. There's lots of good questions.
I'm trying to find ones that are more like high level, apply to
Yeah.
people. I know somebody asked earlier, so if they live in a quote unquote maintenance free, maintenance assisted, i.e. lawn care provided to the HOA, but the owner is responsible for the irrigation repairs, but the HOA is requiring them to use their company to do those irrigation repairs. Are they able to do that?
Great question. I think under the new law, the answer is no. If the owner is absolutely responsible for the irrigation on his lot or her lot, and your preferred vendor is this certain, I think the new law says no, you can't require them to use the vendor that they want, that the board wants.
Yeah. Yeah, it sounds like, and then like you said, Richard, sometimes those things, it can get to where there's a lot of finger pointing because if the irrigation tech that the homeowner hires doesn't fix something right, the grass dies, the grass is responsible of the HOA. It can get that sounds like it can get hairy. There was a question as we keep popping through these.
Well, you look,
It looks like, yeah, there's one, and this may be a self-managed. It says, are human resources contracts completely accessible, including salaries to HOA owners? So
the answer is the management contract that reveals salary information is an official record, and it is available to owners. What the statutes in condos, co-ops, and HOAs are all the same. It basically says personnel records of the manager are not accessible. Okay, so like payroll and payroll records. So you couldn't look at their W-2 or their payroll stub. But then the statute goes on to say any management contract or other information that the board has that may reveal the salaries is available. So effectively, if you know what to ask for and how to ask for it, you're going to be able to figure it out.
There's one here going back to membership roster posted on the website that contains phone numbers and email addresses of unit owners. If we do not have an electronic consent, do we have to redact those owners? Owners have to opt in to allow that information, right?
The statutes, all 3 statutes, as I recall, say the board can publish a roster which contains the name, the physical mailing address, official mailing address, and the phone number of the owner without the owner's permission, except the owner can then say, don't put my phone number on there. That's what you're allowed to do. As far as email addresses, you are not allowed to publish the email address except under 2 instances. One, the person has told you that that email address is their official address for all communication. Then it's just like their physical address, which most people have not told you to do. Or 2, the person voluntarily opts in to allow you to put their email address in there.
all right. This is for condominium association. Let's see, what can a condominium association do if they have someone doing work within the condo without county permits or board approval and has now caused damage to their unit and another unit by stepping on a fire suppression line. And going back to, I think we need to reiterate the difference between HOAs and condominiums. Single-family HOAs license and insurance requirements versus a condominium's license and insurance requirement.
Yeah, I mean, first of all, if they're violating code and don't have permits, you can turn them into the code enforcement office, which sometimes will do something and sometimes not. Other than that, if you're a condo, if they've damaged the again, a condo can still require licensed proof of insurance, all of that. A HOA cannot require a license, but they can require proof of insurance. But in any case, any scenario, if the contractor on behalf of the owner has broken common element or damaged items, then you have legal recourse against them because of their negligence.
Richard, we had a few different people. I don't think we ended up talking about this at the beginning, but we had a few people ask about CEU and then also the board member credit for this particular class today.
Unfortunately, at this point in time, this presentation it's been presented to the state for certification, but they have not certified it yet. Okay, there's a whole story behind all this, but in any case, so when and if they certify it, we might be able to give CAM credit, and we might be able to make it count for your board legal update, at least for condos, which is only an hour. HOAs, remember, 2 hours or 4 hours, so it certainly wouldn't cover that. But the answer is probably not, but we're going to try. If not, there's plenty of these, and we'll
do more.
We'll do more, and there's other attorneys that do them regularly. So it's been a little bit of a bureaucratic nightmare to get all of these new requirements timely approved, because even though it was the law July 1, frankly, the division was not ready on July 1, even though the 90-day clock was ticking on July 1. So classic, impose a new law, but we're not ready to help you deal with it.
We have somebody asking if they moved management portals, do the financials governing documents have to be uploaded all the way back per each doc's retention requirement? So if a doc, has a 7-year retention period, do they have to be available on the new portal by October 1st?
Well, I think that's probably a question you guys can answer, but I don't know where the October 1st deadline comes from. The deadline, if you're required to have, we're already required to have the website under the old law. Yeah, you got to comply. If you're required under the new law, you have until December 31 for an HOA, and you have until December 31, 2026 for a condo.
Let's see. Terry, you asked in an HOA what kind of attorney is recommended to address the builder with documented builder defects. Richard, you have attorneys that specialize in construction defect?
Yeah, you need an attorney that's familiar with construction defect in Chapter 558. Most full-service community association law firms, including ours, most of them will have a whole division that handles those things. Smaller firms may not, but there are specialist construction defect attorneys that can be retained. So ask your law firm. If they don't have the qualified people, then there are plenty of others.
Good. And you've got them too.
Yep.
All right. I think, guys, I really appreciate all your questions. I know we've gotten to a lot of them and we still have 52, but out of respect for everybody's time, it's been a great 2-hour class. Richard has his information here up on the screen. Again, all of you will receive an email from Shauna and I following up with this webinar with our contact information and Richard's. If your question wasn't answered, we will get, please reach out to us. In addition, with what Richard stated about anyone who's in a condominium association, when you registered, as long as your information states that you were in a condominium association, all of the CAMs, Sean and I will keep all of that information. We'll pull it out on an Excel spreadsheet and hold on to that. And then I will be in communication with Richard. And as soon as Richard gives me the yay or nay, what the state says, no matter which way it goes, I will respond to all of you to let you know if if he was able to file it or not. So Richard, I'll just pass that on to you once you hear from the state.
Right, thank you.
All right, my pleasure. All right, great information. I appreciate your time today, Richard.
Thank
Lots
you.
of information. I'll be holding on to this document. And again, Richard stated it's on his website and you'll be getting it in our email.